All right, hi, welcome back. Attorney Steve Vondran, welcome to another exciting episode of Litigation Whiteboard. Okay, in this video, we are talking about what I think is often overlooked tort. Okay, an often overlooked tort. A tort is just a civil wrong one person commits against another causing damages, okay, for which the law may provide a recovery for you, okay? But we are talking about a tort that I think often gets overlooked, even in law school. I don't recall this really even coming up. Usually when you talk about your intentional torts, you're talking about assault and battery, false imprisonment, intentional infliction of emotional distress, and a few other things. But without further ado, let's head to the Attorney Steve Litigation Whiteboard. All right, so we're back. And so this actually came up because of a fact pattern that somebody called me on, and a friend of mine, and I kind of was thinking about it. And she called me and she said, you know, my dad owns a piece of property, and he had it in escrow, so he had a contract with a buyer. Okay, so here we have our plaintiff, or let's just call him our seller. The seller was in a contract, that's what the K is for, with this buyer for a piece of property, okay? So what does the neighbor do? We shall call the neighbor the defendant. The neighbor decides, I'm upset with this person over a disagreement over a well, if you can believe that, a disagreement over a well. So these two were in a little tiff, so to speak. The seller goes to sell to a third party. The deal gets into escrow, you know, waiting to get closed, that sort of thing. This guy starts coming out and pulling out all his trash. Okay, if you can believe this, he wants to be a nuisance. I think there was like a movie on that, wasn't it? Like a Will Ferrell movie. He starts moving all his trash out. Say this is the property here, okay? This is a mountain range. This guy starts moving all his trash up to the lot line, basically, you know, making it look one of two things: less desirable, or makes it look like, oh, there's a crazy neighbor. I guess we don't want to do that. I think that's what the Will Ferrell movie is about. But anyway, so he moves it up here. Buyer decides, you know, I don't need this. It's a nice piece of land, but I don't need this. Buyer backs out. You know, that happens when you're in a escrow. Usually you have an inspection period, an appraisal period, and you have a chance, a finance contingency and things like that, and you have a chance to back out. So this guy backs out because of this guy. At least that would be the allegation. You can do certain fact finding to figure that out, but that was the facts that was presented to me, and she simply asked me, do I have some kind of cause of action for that action? And I said, yeah, let me think about that. Did this person know there was a contract? Did this person know there was a contract between these two parties? She says, yeah. I said, okay. And this person had ever done this before? Is this something new? Never done it before in 30 years, okay? And there's an ongoing tiff here. So the timing was incredibly strange to make it look absolutely intentional, willful, bad faith, malicious, whatever you want to call it. And I said, yes, look at the tort of wrongful interference. Now, this is a state law. Every state is going to have its own version of the law. Okay, they may have a different name for it. It could be tortious interference with contract. It could be wrongful interference with contract. And there's also a tort, even if you don't have a contract, say there's no contract here, there is also a tort of intentional interference with a prospective business advantage, or what some states may call a business expectancy, or an economic advantage, an interference. So check that out. If you have these fact patterns, check it out in your state, see what your state statute says. But just in general, I think these are the elements that you're looking for to get into your complaint. And as we're always trying to say, you want to make a prima facie case when you file your complaint. What does that mean? It means you want to have facts to support each of these elements so you don't get knocked out on a demur or a motion to dismiss, whatever your state calls it, okay? California state court, it's a demur. Arizona state court, it's called a motion to dismiss. Federal court, it's called a motion to dismiss. Okay, but you have to have the existence of a contract. Okay, contract. You can check out what you know what a contract is. It's a promise or a set of promises that the law will enforce. So you have to have an actual contract, knowledge of that contract by this person, the tortfeasor, there's a good word for you, the tortfeasor has to have knowledge of the contract and intentionally interfering, which induces the breach of contract, okay? Intentionally interfering. Now, intent, as you know from your law school class, it's where you intend to do something, intend an act. You don't need to necessarily intend the outcome, but you intend the act, or you have knowledge with substantial certainty. Knowledge with substantial certainty. That's good for your bar exam takers. You throw that down there, or knowledge with substantial certainty, and then argue that. Wonderful. Pick up your points. And then wrongful conduct. So many times you're going to see that you need not only the intent, but some kind of wrongful conduct, like this person moving the trash and, you know, may have been within the rights, but let's face it, it was motivated by bad faith, ill will, spite, all those great words, okay? And then it has to cause damages, okay? Check your state. You may be entitled to punitive damages. I have a video on punitive damages. What's that? Damages designed to punish and deter so they never do that again, to send the message, okay? So everybody loves punitives. Check your state. You may be able to recover attorney fees. My guess would be probably not, but check your state statutes. This is not legal advice or a substitute for legal advice. But that's it. That's the tort. I call it the hidden tort of wrongful interference, tortious interference with contract, tortious interference with prospective business advantage, and that kind of thing. So I have over here, when you get to this tort, that separate tort, prospective advantage, it needs to be something that's more than a mere hope, okay? Like, well, I thought I was going to get a deal, or did it go into escrow? No, it didn't, but, you know, I was hoping it would. That's not going to be enough. And show some types of business relationship. If you're looking at a business type of tort, interfering with a business relationship. But remember the defense of competition. Okay, there is a thing called fair competition. Okay, now how far that goes, that's things that gets litigated in the courts. But there you have it. That's another exciting episode of Litigation Whiteboard. If you need help with an interference claim, okay, give us a ring. You know where to find us on the web at attorneysteve.com. That's attorneysteve.com, the first name in legal services. I got to run, got a big day ahead, so hope you all enjoyed this. Feel free to give it a like. It's not going to hurt you. Punch the like button. And how about a subscribe? We're going to get up to 35,000 next year, maybe more. So thank you all for following. Bye now.